Yeah. So this bill, it would do a lot of things, right? It's specifically designed to overhaul pretty significantly the antitrust laws as they stand today. And it's been couched as fostering the ability of the antitrust agencies to do their job effectively. But looking at the text of this bill, what it seems to translate to is to making it much easier for plaintiffs to win antitrust cases. So it does things like lowering the burdens of proof across the board. As Ashish mentioned earlier, it would change how we're defining exclusionary conduct to bring in a lot more things and, in a lot of ways make it a bit more confusing for reasons he discussed. On the merger side as well, it would also, change the requirement that you show that conduct is likely substantially to lessen competition to this lower standard that is that it would, create an appreciable risk of materially lessening competition, where materially is defined as just more than a de minimis amount. It also shifts the burden of proof in some significant cases or instances. So it would shift the burden of proof for certain merger challenges and require the parties to certain acquisitions to prove out of a presumption that they should not be allowed to proceed, which is, a pretty drastic change to, the way the law is today. And on the conduct side, similarly, it would, amend the law to create a rebuttable presumption of harm for, so-called dominant defendants. And I think there are a lot of very real concerns with the proposed legislation, including that, flipping the burden of proof against the defendants in this way seems to be, really a drastic step that shouldn't be undertaken lightly, especially, in the US, we take the rule of law very seriously, and that's really a pretty monumental change. To take a step back for a second, a key premise of this legislation also seems to be that it's simply too difficult for the antitrust agencies to stop anti-competitive conduct today. Now, that's really a testable proposition. We can look at the cases the agencies are filing and see how they're doing in court. And Jan Rybnicek, who, I've had the opportunity to work with quite a bit, and who is an excellent antitrust attorney, kind of looked at the data and found that over the last 20 years, the DOJ and the FTC have prevailed in nearly 85% of merger challenges they filed in court. That's really an astounding win rate, especially given, again, the text of this bill that would across the board lower the standard and in some cases go so far as to flip the burdens of proof in these cases. And there are, a lot of reasons to kind of think that that's an astounding win rate. There's frequently this rebuttal by critics that the agencies are just really good at picking cases to bring, right? It's, these selection effects. And I've worked with both agencies and absolutely agree that agencies, do a really good job of thoroughly working through the issues and, thinking hard about which cases they want to bring and where they really see harm. But it still takes two to tango, so to speak. So if these cases are going to trial, it means not only that the agency selected them, it also means that the parties were willing to litigate, which presumably means they thought there was a decent chance they could win. So, there are selection effects on both sides of the equations, and it's not just the agencies dictating which cases are litigated. So that 85% win rate isn't fully explained by agency choice alone. And remember, that rate doesn't even include a lot of deals, right? It doesn't include those deals that were abandoned once the agencies filed a complaint or otherwise indicated to the parties that they were going to challenge the merger. It doesn't include those where settlements were achieved, which, again, I mentioned some data I pulled earlier of, regarding DOJ filings over a 21-month period. There I found, over that whole entire period, only 4 of the complaints that were filed did not include simultaneous settlement agreements. So that's, the filing of a complaint and a simultaneous settlement happens quite frequently. And again, kind of shows that the agencies often don't even need to get to court to, get remedies and to solve these problems. And of course, the data also doesn't include, because, it can't, those deals that the parties, that never materialize, right? The parties consider and reject before they even get to the HSR filing, which, having worked in private practice for several years, I can also assure you does happen even in the big tech space. So, it's pretty clear the agencies can and routinely do already win at trial. So, it's kind of unclear the problem this legislation is actually solving. And, I think it, also to your point, threatens to do potentially quite a bit of harm, right? It raises the cost of, conduct kind of across the board, right? It puts you at a lot of risk as a company. It makes it much harder, in particular, for small companies, right, who kind of rely on this pipeline of, being able to, build a company, potentially sell it off, it's impairing there. And it's also, when you're creating a, more aggressive, more, intervening regulatory regime, that tends to disproportionately harm smaller businesses who don't have the resources, to, spend so much additional costs on, legal and all of those things. So I think that's a very real threat. And there's a lot of, potential for harm here.